October 30th, 1984. Plaintiff, Garner, deceased minor, and his father. Defendant, State of Tennessee, and Officer Ellen Heyman. Law enforcement officer pursuing an unarmed suspect may use deadly force to prevent escape only if the officer has probable cause to believe that the suspect poses a threat of death or serious injury to the officer or others.
Alright, man. Me and my partner got a night prowler call. That's mission's address. Is that you that called?
Yes, sir.
Alright, tell me what happened.
I heard glass breaking next door, and I heard some noises out back and shuffling in the leaves.
Okay. That it?
Yeah.
Alright. Did you come from this house or was it this house? Which one?
The one on the left.
You came from this house right here?
Yes.
Alright, stay right here for me. Go back to the car, tell them 10 floor, everything like that. I'm gonna go search the back of the house. Me and my partner, Officer Leslie Wright, were called out to a night prowler call in Memphis. We responded to the call. The lady told us what was happening. My partner went back to the car to radio in that everything was fine. I noticed the defendant, Mr. Garner's son, running out the backside of the house. I pursued him, caught him by a fence, told him to remain still. He proceeded to jump over the fence. Acting under the Tennessee statute, police officers can use deadly force to stop a non-dangerous suspect from evading the police. That being said, it is not unconstitutional to act underneath that statute, which is exactly what I acted under. Officer Hyman, got someone running, starting foot pursuit, need backup. Memphis police, get down! Get down! Get down! Stop running!
The court appealed and revised and remanded the 710 F.2D 240 in response to the killing of a fleeing suspect is a seizure under the Fourth Amendment and 6, and is therefore constitutionally only a reasonable. The Tennessee statute failed as applied to this case because it did not adequately limit the use of deadly force by distinguishing between felonies in a different magnitude. The fact as found did not justify the use of deadly force under the Fourth Amendment. ID point at 246, officers cannot respond to deadly force unless they have probable cause to believe that the suspect poses a threat to safety of the officer or a danger to the community if left at large. ID 7. Whenever an officer restraining the freedom of a person to walk away, he has seized that person. United States versus Brain Ponce de Leon 422 U.S. 873-878. While it is not always clear just when minor police interference becomes a seizure, see United States versus Mendel Hall 446 U.S. 544. There can be no questions that occurrence by the use of deadly force in seizure subject to the reasonableness requirements of the Fourth Amendment.
Get down! Stop running! Stop running! Officer Hyman, shots fired, suspect down. I need an evac. Right now, stat!
And go.
The court affirms on the ground that application of the Tennessee statute to authorize Officer Heyman's use of deadly force constituted an unreasonable seizure in violation of the Fourth Amendment. The precise issue before the court deserves emphasis because both the decisions below and the majority obscure what must be decided in this case. The issue is not the constitutional validity of the Tennessee statute on its face or as applied in some hypothetical set of facts. Instead, the issue is whether the use of deadly force by Officer Heyman under the circumstances of this case violated Garner's constitutional rights. Thus, the majority assertion that a police officer who has probable cause to seize the suspect may not always do so by killing him. Ante at 9 is unacceptable, but also of little relevance to the question presented here. The same is true of the rhetorically steering statement that the use of deadly force to prevent the escape of all felony suspects Whatever the circumstances is constitutionally unreasonable. Ante at 11, the question we must address is whether the Constitution allows the use of such force to apprehend the suspect who resists arrest by attempting to flee the scene of the nighttime burglary of the residence.